Hello, good afternoon, everyone, and thanks for joining us today for our first financial services focused webinar of 2025. It frankly feels incredible that we're already into February, but there we are. My name is Liam Salt, and I am the Business Development Manager at Mitchell supporting our financial services teams. We're joined today by some of my colleagues, Tom Walklett, who is a Senior Associate in our Restructuring and Insolvency team, who's going to be talking to you today about bankers set-off. Nick Jennings, a Senior Associate in our Banking and Finance team, and Penny Coggo's a partner in our Pensions team. We'll be talking about the impact of Pension Schemes Act 2021. And Aisha Hassan, who is a partner in our Real Estate team, and will be covering off key developments in real estate for us today. Just before we kick off, just a little bit of housekeeping for everybody. The session will be recorded, and we will circulate the recording afterwards for anybody that wants to watch that back. If you've got any questions for our panel, we will have a Q&A session at the end today as well, and you can see our panel there on the slide. Please do drop those questions into the Q&A function that you'll see at the top of your screen. They just come straight through to us. You can submit any questions in there. Do include your name and your organisation as well, if you could, please. And what we'll do is, if we can't get to your question for whatever reason today, then we'll do our best to reach out and follow up with you directly as well. We've got about 90 minutes allotted for today's session. We might, depending on how the Q&A goes, finish a little bit sooner than that and give you a bit of time back. Questions into the Q&A, sorry, and we will be circulating a feedback form as well, so I'll drop that into the Q&A box as well in a moment. We'd very much appreciate if you could complete that if you get a second to take a look at it. Just let us know how you think today's session went, and also anything that you might want to hear about from us in the future. So at that point, I'm just going to pass over to Tom Walklett to kick us off. Tom?
Thanks very much, Liam. Good afternoon, everyone. So thank you very much for joining us this afternoon. As Liam says, my name's Tom Walklett. I'm a Senior Associate in our Restructuring and Insolvency team at Mitchell, based in our Birmingham office. Now, I know today's session was titled Key Developments or Key Updates for Lenders. That's going to be a bit of a misnomer in terms of the first topic that we'll be covering today, which is going to be a bit of a back to basics and an introduction to set-off. Now, recently completed a secondment at a very well-known high street clearing bank, some of whom I'm sure will be on the webinar today. And during my time on secondment, I found that set-off came up an awful lot, particularly in relation to its scope and as and when it can apply. I've always taken the view that set-off is a bit of an unsung hero, really, in a lender's arsenal in terms of a form of quasi-security. So I thought it would probably be a good idea to look to do sort of, say, a bit of a back to basics session in relation to set-off, its scope, and when it will and won't apply in a restructuring context. So if we just have the next slide, please. Thank you. So set-off, what is set-off? It's an umbrella term. So it basically applies where you've got mutual dealings between two parties. So a very typical example would be Party A has a money claim against Party B for, say, £100,000. Party B, in turn, has a claim against Party A for £50,000. Set-off applies to set off the money that's owed by one party to another. So you have a single net balance that's owed one way. So using those figures, that would result in a £50,000 claim that Party A would have against Party B. Now, there are 5 main types of set-off. The first 2 types, sort of going through the list as you see it on your screen: legal set-off. It's also sometimes known as statutory set-off, which is the basis of a set-off defence in civil proceedings, whereby a counterclaim is used to reduce liability under a claim. A really good example of that might be where you've got a building contractor, a client doesn't pay an invoice owed to a building contractor, and then the building contractor brings a claim against the client for unpaid invoices, and the client looks to set off claims it may have against the contractor in respect of defective works. The second form of set-off is equitable set-off. That's also sometimes known as transaction set-off. That applies outside of litigation, and it's based in equity, and it essentially applies in circumstances where you have two mutual claims owed by one party against another that arise out of the same circumstances or facts, and the two claims against each party are so closely related that it would be inequitable for set-off not to apply, for there to just be a single net balance that applies as between the parties going one way. Now, the remaining types of set-off are probably the most important forms of set-off relevant to finance transactions, and that's what we'll be examining in a little bit of detail today. So turning to those each in turn, first being contractual set-off. That arises where we have a right of set-off that's created in the contract or agreement, which in the lending context is normally found in the banking standard terms and conditions relating to current accounts, a facility agreement, or under relevant security documents. We also have insolvency set-off, which is a statutory remedy found in the Insolvency Act 1986 and also under the Insolvency England and Wales Rules 2016, that provides that where there have been mutual credits, mutual debts, or other mutual dealings between a creditor and a debtor prior to the commencement of an insolvency procedure, an account will be taken of what is due from each party to the other in respect of the mutual dealings, and the sums due from one party will be set off against the sums due for another, due to the other. That applies automatically as a matter of law. And then also bankers set off, which is known as current account set off. Now, generally speaking, bankers set off won't be particularly relevant in most contexts because a lender will generally have pretty robust contractual set-off provisions in its facility documents and security, but bankers set-off is an old common law remedy that applies to banks or lenders, and it confers on them a general right to combine two or more accounts held by the same entity. So that means they can set off a debit balance on one account as against a credit balance on another. So say, for example, a loan's matured, remains outstanding, a bank would be entitled then to apply any credit balances in a current account as against that loan, and create a single balance that's generally owned by the customer then to the bank. Just have the next slide then, please. So what does contractual set-off do? Well, the purpose of contractual set-off is to extend or restrict the right to set off beyond its scope in law or in equity in favour of a lender. So normally what that does is it permits set-off of claims which are not mutual. So as I've sort of said, what's required for set-off to apply, generally speaking, is for there to be mutual debts that are owed by one party to another. And it also may permit set-off claims which are not yet due and payable, such as unmatured, unliquidated, and contingent claims. So what contractual set-off does is it really exists as a separate form of set-off that applies over and above the other forms of set-off that I've already identified, without replacing them or excluding them, and it's free from the limitations that you see that govern the other forms of set-off. The key benefit of contractual set-off clauses is they enable the parties to determine how and when the set-off should take effect, and know their potential liability at the outset. So, for example, a bank's standard loan terms and conditions may permit a banker's set-off, under which, in the event of default, the bank can seek repayment directly from another account held by the customer, which is in credit. So I think a really good example of where contractual set-off can apply, and it will put the bank in a better position than just relying on the standard position under banker's set-off, would be in relation to sort of mutuality of debt. So a really good example might be where you've got a loan that's advanced to a group of companies, or you may have advanced a loan to a parent of a group, and those monies then have been applied across the group. What a standard contractual sort of set-off provision will do is allow the bank to set off against monies that are held in accounts held by other entities of the group within that group. So, for example, if you've got an outstanding loan that's owed by a parent to a bank, and then a subsidiary of that parent has a credit balance, generally speaking, contractual set-off provisions will entitle the bank to set off that credit balance owed by a subsidiary as against the indebtedness owed by the parent. Sometimes you also see it, though possibly a little less commonly, whereby a bank is entitled to set off credit balances that the bank that are held by the bank by a customer against unmatured sums that are owed under a loan. Generally speaking, it is something that you see. It's generally not that commonly exercised from a sort of treating a customer fairly perspective, on the basis that banks generally don't like to look to apply credit balances against unmatured liabilities. But it is something that you do sometimes see, and it may well be in the contractual documentation, even if it's not routinely exercised. What contractual set-off can't be used to do is to contract out of insolvency set-off, which applies where if the borrower becomes insolvent, the rules of insolvency set-off displace all other forms of set-off which haven't been exercised prior to the insolvency process. Just also want to quickly touch upon sort of voidable transactions as well. Now, normally that would sort of take up another session. And whilst it's possible that an insolvency practitioner, in the context of an insolvency scenario, of a debtor could seek to set aside the set-off, arguing that it's a transaction at an undervalue or a preference, generally speaking, it's quite rare for that to be seen, on the basis that for a transaction to be challenged by an insolvency practitioner, it usually requires some sort of desire to prefer, or a company looking to put a lender in a better position than it would otherwise be in insolvency. And because set-off is a self-help remedy and a form of quasi-security, I've seen it argued a couple of times, though it's very hard to see a situation in which set-off applied by a bank would be genuinely challengeable by an insolvency practitioner. So we just see the next slide, please. You may or may not be able to see it on your screens, but I've just included here a couple of example clauses of set-off, of contractual set-off. And you'll see in particular the provisions that I've included here from a term loan, a corporate guarantee, and also a debenture. They all apply before the bank has made demand. That's very important. Generally speaking, in an insolvency scenario, it can be very important for a lender to move exceptionally quickly to protect its position and protect any credit balances before they're dissipated or paid over to an insolvency practitioner to cover fees or whatever it might be. Often there isn't time to actually make demand, and the bank needs to act very, very quickly to sweep accounts. So this is a really good example of where contractual set-off will improve the bank's position over and above bankers' set-off, which might potentially require the bank to make demand to ensure that any liabilities owed by a borrower are accelerated under the terms of the facility agreement. Next slide, please. We'll just touch again on bankers' set-off. As I've already mentioned, it's relevant where a party holds several accounts with a lender, and unless otherwise agreed by the parties, the common law principle is that banks have a general right to combine two or more accounts held by the same entity. That means they can set off a debit balance on one account as against a credit balance on another. That can apply in different currencies as well. So, for example, where a customer has a current account that's in, say, US dollars as against a liability owed to the bank in sterling, the bank will be entitled to convert the amount that it owes to the customer in the form of a credit balance to sterling as at the bank's spot rate on that date, and apply it against the indebtedness of the customer to the bank under the term loan facility. Again, I've already mentioned it, but bankers' set-off can't be used to contract out of insolvency set-off, which if the borrower becomes insolvent, the rules of set-off of insolvency set-off will displace all other forms of set-off. So again, you can't contract out of it, and bankers' set-off won't trump the application of insolvency set-off. Next slide, please. So I've set out here in a very brief table insolvency set-off and when it will apply. So as I've sort of said, it's a right of set-off that arises because of the insolvency legislation. It's statutory, it can't be contracted out of, and it applies automatically. So focusing on corporate insolvency, the rules relating to liquidation set-off and administration set-off are contained in the Insolvency England and Wales Rules 2016. The relevant date at which insolvency set-off will apply will differ depending on the form of the insolvency procedure. So in liquidation, the relevant set-off date is the date on which the company enters liquidation. The reason for that is that liquidation is a terminal insolvency process, and set-off applies as an exclusion to the general pari passu principle. And it's considered, well, it's considered administratively easier for an insolvency practitioner for insolvency set off to apply where there are mutual credits, and it just creates a single balance owed either by the company to the debtor or to the debtor to the company. And in administration, however, the relevant debt off date is when the administrators give a notice that they intend to make a distribution to creditors. The reason for that is because administration, unlike liquidation, it's not a terminal insolvency process. The whole point of administration is that it's intended to allow the rescue of a business as a going concern. And if set off were to apply from day one, it would hamper the administrator's efforts to collect debts that are owed by debtors and potentially the ongoing viability of the company. So in those circumstances, insolvency set off will only apply in administration where an insolvency practitioner or administrators give a notice to creditors that it intends to make a distribution to creditors. In those circumstances, then insolvency set off wouldn't apply from the date that the company enters into administration, and a lender would typically have to rely on its contractual set off provisions in under its security or in its facility agreements or under its general terms and conditions. See the next slide, please. As I say, insolvency set off, it's self-executing, it's mandatory, it can't be restricted, can't be extended or contracted out of by agreement between the parties, and it takes precedence over any other form of set-off exercise before the liquidation or administration of the debtor. A court can't ignore the rules of insolvency set-off as part of the exercise of its discretion. For there to be set-off, there always needs to, however, be two separate claims. Set-off can't occur where you've got a continuous flow of debits and credits. As with such an account, there will always be a running total and there will always be a balance payable. Next slide, please. Just to touch as well on secured liabilities. So it always used to be the case that if you've got a secured debt in an insolvency procedure, your secured debt doesn't form part of the insolvency procedure because you can rely on your security, and essentially it's the realization of that security that's then used to discharge the secured debt. So a secured creditor wouldn't then be required to submit a proof of debt in an insolvency. And for that reason, there was previously a line of case law that said because the debt doesn't form part of the insolvency procedure more generally, insolvency set-off can't apply except to the extent that there's an unsecured part of the debt. So you need to have an unsecured part of the debt, and the debts need to be equally ranking for set-off to apply. The recent, well, I say recent, 2017 now, the Lehman Brothers case, 2017, the reference is up there. That's overruled that previous line of case law and has established now that even where you've got a secured debt and a liability owed by the company to the lender, even where the lender's debt is secured, the lender's still entitled to apply set-off, and insolvency set-off will still apply to that debt, notwithstanding they don't rank equally. So you've got a secured element and an unsecured element, it will still apply automatically. Next slide, please. There are a few minor exceptions to insolvency set-off. I don't intend to go into any real detail on them, save that it's probably sufficient just to clarify that insolvency set-off won't apply where a debt arises out after the date that a company enters into an insolvency procedure, or where the debt arises in circumstances where the insolvency procedure was imminent or the creditor had notice of the intended insolvency. All they are sort of anti-abuse measures to try and avoid a situation whereby a company is able to prefer a specific creditor by essentially creating a debt in the very sort of twilight moments of the company before it enters into an insolvency procedure, to give that creditor a form of quasi-security in respect of its debt, because ultimately that's what insolvency set-off is. It operates as an exception to the pari passu principle, and effectively gives a creditor security by having a debt that's owed to it by the company. Next slide, please. Now we're going to have a Q&A session sort of at the end of this session once my colleagues have had an opportunity to speak. But I did just want to run through a couple of common questions that I saw whilst I was on secondment, because I do find that these tend to arise quite often. And I thought it would probably be helpful just to have a quick run through some of these. though obviously happy to field any further questions that you may have at the end of this. The first, does the bank need to make demand before applying set-off? Generally speaking, no. Your terms and conditions, I strongly suspect, will provide that set-off will apply before demand is made. The liability being set off, generally speaking, again, will have needed to have fallen due, but in practice that won't usually be an issue because an acceleration event will usually have occurred. So you have two liquidated claims that are capable of being set off. If you don't have a liquidated claim, generally speaking, you will need to make demand under your facility to trigger an acceleration event. And if you need to do that, generally speaking, you can make demand and wait maybe a couple of hours to allow the debtor time to operate the mechanics of making payments before you operate set off. Though that's not always essential. Can set off apply across accounts? I think I've already mentioned this, but absolutely, yes, it can. Its operation of bankers set off is particularly wide and will apply to multi-currency accounts, but it won't apply to accounts held in joint names or accounts that are held on trust for a third party, also sorts of trust accounts. So you need to be satisfied that the debtor, if you've got a credit balance in an account, that the debtor is beneficially entitled to those monies for set off to apply. And we can help. We can advise in circumstances where there may be a bit of nuance in relation to the basis on which funds are held and if they are being held on trust for third parties. Do the provisions of Section 127 of the Insolvency Act preclude the operation of set off? So just for those that aren't aware, Section 127 of the Insolvency Set Off provides that where any dispositions are made by the company before after it enters into liquidation, then they will be void dispositions and will be set aside. The date on which the company enters into compulsory liquidation is deemed to be the date on which a winding up petition is presented against the company. So you often tend to see a situation where a winding up petition is presented. There is then a gap of time before a compulsory liquidation order is made, or a liquidation order is made, or winding up order, I should say. And in that interim period, there have been various dispositions of property by the company. Section 127 means that those dispositions are automatically void. It has been raised before as to whether Section 127 would preclude the operation of set off. We take the view that it wouldn't. On the basis that it's not a transaction in any meaningful sense that's entered into by the company, rather than a contractual right or a form of quasi security that's operated by a lender. Though again, if that's something that if you do ever exercise set off in the course of your professional lives, and you do see it challenged by a liquidator, that's something that we could assist with. Just quickly, touching on whether set off's challengeable as a preference. I've mentioned it previously. Generally speaking, we don't expect set off to be challengeable as a preference. For something to be a preference under the Insolvency Act, a company needs to have a desire to prefer the person receiving the preference, but also it requires something to be done by the company to have the effect of putting a lender or a creditor in a better position in insolvent liquidation than they would otherwise be. And because set off is self-applying, and it's a self-help remedy applied by the lender, the conditions for a preference to apply won't usually be met. So even though we've seen it raised by insolvency practitioners previously, it's very hard to see a situation where the exercise of set off would ever actually be challengeable as a preference in the true sense. In relation to, just moving on to whether money's mistakenly sent to a liquidation account in error by the bank could be recouped by operation of insolvency set off. Again, this is something we've seen a couple of times where companies enter into liquidation, and an insolvency practitioner writes to the lender asking for monies in a client account in the company's account to be transferred into the liquidation estate. And we've seen it happen whereby internal teams haven't taken appropriate steps to ensure there's no outstanding indebtedness before doing that. We have managed to successfully challenge that and recoup those monies by arguing that insolvency set off applies on the basis the company was in liquidation and any credit balance was automatically set off against any liabilities owed by the company to the lender. So again, if that's something that you see happen, it's something that we can absolutely assist with, and we've got a track record of having been able to recover monies on that basis for the benefit of a lender. Now, I'm very conscious of time, and we're already at 5 to 3. So I will touch on these final questions if we have time at the end. But otherwise, I'll hand over to my colleagues, Nick Jennings and Penny Cugger, for them to touch on Pension Schemes Act 2021.
Thank you, Tom. That was a really useful resume of set-off and recoupment. We're here to talk about pensions and the Pension Schemes Act 2021 and what lenders need to know about it and what they need to look out for. I'm a pensions partner at Owen Mitchell, and Nick is a senior associate in the banking team. Next slide, please. So by way of background, the Pension Schemes Act 2021 has been law since October 2021, but it's becoming of increasing concern to lenders. Why? Because it's very wide-ranging and it has to be considered when loans are being taken out, as the protections provided by the Act cover borrowing. They can also cover enforcement in certain circumstances. And of course, defined benefit final salary schemes can be an employer or a group's largest creditor. The Pension Schemes Act 2021 has been a long time in the making. It gives enhanced powers to the pensions regulator, TPR, who regulates defined benefit final salary schemes. Since 2004, the pensions regulator has been able to impose contribution notices and financial support directions on employers, groups and shareholders that mismanage defined benefit plans to require them to properly support the plan financially. But that's been insufficient to stop the type of pensions mismanagement we've seen in the past with British Home Stores and Carillion. Just as a quick update, for those of you who weren't around at the time, Philip Green, who owned BHS, was accused of having sold BHS for £1 to Dominic Chappell to deliberately avoid the scheme's pension liabilities. Philip Green later did a deal with the pensions regulator and paid £363 million to the pension scheme, when its deficit was £571 million. But that took a lot of work from the pensions regulator to get that result. And that's why the Pension Schemes Act 2021 creates 2 new offences. These are civil offences and criminal offences for anyone who, without reasonable excuse, engages in activity that has a material or detrimental impact on scheme benefits, and the person knew or ought to have known this, or for anyone who, without reasonable excuse, commits an act that prevents a pension scheme from recovering all or any part of their statutory Section 75 debt from the employer, with the intention that the act would have that effect. The criminal offence has to be proved beyond reasonable doubt, and the civil offence is looked at on a balance of probability basis. The whole Act is regulated by the pensions regulator, and the aim is to give defined benefit plans some real protections, but it's quite a blunt instrument. Initially, the pensions regulator decides what is a reasonable excuse. In doing so, the pensions regulator takes account of its statutory objectives, and these are to protect the security of members' benefits and to reduce the number of schemes that fall into the Pension Protection Fund, the PPF, the safety net for insolvent defined benefit schemes. As well, the pensions regulator has to adopt a proportionate risk-based approach to enforcement. The pensions regulator is funded by public money. Next slide, please. The new offences under the Act should be considered by all companies that operate defined benefit schemes. But it's not a problem for schemes that are in surplus on a buyout basis. That's sometimes called a statutory Section 75 basis. Buyout basis is when the scheme has sufficient money to be able to secure all members' benefits with an insurance company. It's regarded as the gold standard. If the scheme is funded at the gold standard basis, there's no need to worry about the Pension Schemes Act. If it's funded at any lower basis, then the Pension Schemes Act starts to be relevant. But again, if the scheme is 100% funded on a low dependency basis, then the Act will be relevant, but the loan is less likely to cause issues. Why? Because it's 100% funded on a low dependency basis means that the scheme has sufficient assets to be able to self-finance itself for the rest of its life. It's reached self-sufficiency, so no employer contributions are required. Any funding levels lower than that, and the scheme does fall fully within the scope of the Pension Schemes Act 2021. And then to put this in context, the pensions regulator issued figures in January 2025, and it said that of 4,818 defined benefit schemes, 49% are fully in surplus on the statutory Section 75 buyout basis, 75% are in surplus on a low dependency funding basis. And it's worth noting that all actuarial valuations for all schemes have to be done on that basis now going forward. And 85% are on surplus on a technical provisions basis. And if they're in surplus on a technical provisions basis, then they are caught by the Pension Schemes Act 2021. So if you have got a lender that does have a defined benefit scheme that falls within the scope of the Act, then all parties need to tread very carefully. Next slide, please.
Thanks a lot, Penny. So clearly for pension professionals, the Act's an absolute nightmare. But why as lenders do you care about this? Well, it's because unfortunately it's so widely drafted that the mere act of making finance available or taking security from a company which operates a defined benefit scheme could put you in breach of this Act. That's how widely drafted it is. Now, the good news is that the pension regulator has issued guidance to the effect that ordinary course lending is unlikely to be prosecuted. But unfortunately, that's only unlikely. The bad news is the Pensions Act does not provide any kind of statutory safe harbour for lenders. And what that means is any time you either lend money, extend a loan, or take security from a company with a defined benefit scheme, you do need to consider this legislation. And there's no materiality threshold here either. So even though it might only be a small increase or a short extension, that unfortunately doesn't obviate you from considering whether there's any issues with the pension scheme here. And I mean, that applies to all companies. It applies even more so where you're lending to companies which are in financial distress, because clearly there you're aware in advance that actually they're having trouble repaying their existing debt, let alone any new debt that you might give them. And so while you might be making that loan with the aim of saving the company, that's not necessarily the relevant consideration. What you need to think about is whether actually that gives the best outcome for the pension fund, or the pension scheme, or whether actually some other course of action, such as, for example, immediately winding up the company would actually have given them a better outcome. It's their considerations which are put first, not the considerations of the company itself. And that's really important to remember here. And what if you get this wrong? Well, it's really, really quite serious. It can lead to not just corporate liability, but also personal liability for yourself. And in the worst case, you can be given an unlimited fine or even up to 7 years in jail. So it's something that's really, really important. This isn't just of academic concern to lenders when they're making loans in these scenarios. Next slide, please.
So the intention of the Act is not to inhibit normal commercial lending activity, and that's what the pension regulator has said. But once the scheme is in the scope of the Act, then obviously lenders, advisors, trustees, employers are all going to be wary because no one wants to commit a criminal or civil offence. Plus, the pensions regulator has a look-back period of 6 years. So once the scheme is in scope, past and current behaviours can be scrutinised and looked at overall. And as I said before, the Act is very much a blunt instrument. There's no materiality threshold, so all lending should be scrutinised. But it's only really going to be a concern depending on the circumstances. And here, I mean, the circumstances of the scheme and the financial circumstances of the employer and the group. And so it's not really surprising that lending to a distressed company requires a greater level of scrutiny. When a lifetime of finance is being requested and the bank is getting security for this, then that has to be compared to what impact that lifeline is going to give the scheme and its security arrangements and its financial position, because there's obviously only so much security to go around. If the lifetime works, all well and good, everyone's happy. If the lifetime fails, did the extra lending make the scheme's position significantly worse? Well, there are some financial tests that are done to try to work this out. And the pension regulator in its blog has given some guidelines as well. So what the pension regulator said is that they will look at whether the Act, in this case the loan, coincidentally had a detrimental impact to the scheme, i.e. was it part of the usual banking activities, Or was the loan, a fundamentally necessary step to achieve the purpose, where the purpose has a detrimental impact on the scheme? And this is more where the purpose was specifically to avoid defined benefit pension scheme obligations. So that might be intergroup loans, or where loans are being stacked up on an employer that has a direct financial responsibility to support the defined benefit scheme, perhaps combined with a payment out of a large dividend. The pension regulator will also look at whether there was a viable alternative that would have avoided or reduced the detrimental impact on the scheme. Going back to the lifeline as an example, the answer there may be that there was no viable alternative, which is fine, but there may have been a viable alternative. There may have been some funds available from a shareholder that might have got the company or the group in the same type of financial position. So it does all have to be worked through. In terms of the further tests that should be looked at, well, they're set out on the next slide. The next slide, please. The process that the bank needs to follow to make sure that it ticks its boxes and gets as much comfort around the pension requirements is that the bank needs to be confident that the employer or the group has shared information early on with the pension trustees about the proposed loan, the terms, how the loan is going to be financed, any changes in security, any impact on the affordability of the already agreed pension contributions. And then the trustees have to go away and take their own professional advice on the loan and its impact on the scheme and be given sufficient time to do this. And they'll be looking at taking advice from the scheme actuary on the scheme's current funding position and whether those contributions can be afforded going forward with the extra security or the change in security, or whether the contributions themselves should be tweaked because of the loan. And the trustee should also be taking advice from their employer covenant advisor. And they want to understand the impact on the employer or the group to service the loan and to support the scheme. And there, the specific tests are to look at the impact of the loan on the cash from the cash flow perspective immediately before and after the loan takes effect, and also to look at the position on the balance sheet perspective immediately before and after the loan takes effect. So that's basically on an insolvency basis. If there's a potential for the loan to have a materially detrimental impact on the scheme, then the trustees and their advisors are expected to negotiate with the employer and its advisors and potentially the bank to reach an acceptable position. It's crucial in doing this that conflicts of interest between employer and trustees are fully recognised and properly managed, and often having a professional trustee involved can be very useful. Next slide, please. The process from the bank's perspective, if the loan is looking like it's materially detrimental, then the trustees can look for various possible solutions or a combination of the following. So they can ask for accelerated pension contributions from the company or the group. They can look for a share of profits or a share of cash flow if there's an upturn in the business. They can perhaps look in place to put immediate funding triggers for the scheme if there's a downturn. They might want some collateral security for the scheme, a charge on a property. They might want some money set aside in an escrow account or letters of credit. They might want the guarantee from the broader group, in which case you have to look at that very carefully. And you want to make sure that that guarantee has got a full look-through basis. And you might want to back that up with change of control triggers or disposal triggers so that the guarantee remains worth what the guarantee has been put in place to safeguard. And as I said, it is in the interests of all to reach a satisfactory conclusion. Otherwise, everybody's potentially at risk from the pensions regulator. There is no clearance from the pension regulator for these new offences under the Pension Schemes Act 2021, but clearance is available for contribution notices or financial support direction risk. And these affect the employer or the group or the trustees. But even if the regulator puts these in place, they only give unsecured creditor status, which is the same status actually as unpaid pension contributions. They're also unsecured creditor status. There is a bit of a question that if a bank enforces a charge over shares, it could potentially fall within the scope of the kind of contribution notice or the financial support direction. as it then potentially becomes associated or connected with the employer. So care has to be taken there. Once agreement has been reached, or if the trustees conclude that there's no materially detrimental impact on the scheme, then make sure this is documented, because you do want that paper trail. Next slide, please.
Yeah, thanks a lot, Penny. So, I mean, if there are two takeaways really from this talk today for banks, it's firstly that lending to companies which operate defined benefit schemes is a lot more complicated than if they don't. But secondly, it doesn't mean you can't do it at all. There's just a few additional hoops to jump through. So what should you actually think about as a lender? Well, firstly, and possibly most importantly, due diligence at a really early stage is absolutely essential. Now, inevitably, any loan agreement will contain a representation to the effect that, there's no DB schemes, only defined contribution schemes. But if you're only finding out about it at that stage, it's kind of a bit too late. I mean, at the very least, it's going to delay the transaction. Or in the worst case scenario, if actually you find out you can't lend because of the pension scheme, well, all the work you've done up to that stage then is wasted. So it's really important you find out as early as possible if one of these schemes exists. If they don't, which to us does tend to be the case, all well and good. If they do, then at least you know about it and there's things that you can do. And in terms of what you can do, well, look, it is mainly taking expert advice at the earliest stage possible. All these issues are manageable, or at least you can come to a kind of a sensible decision about it, but it's not something that can be done really, really quickly. So the earlier you know about it, the more likely it is you can get a good result. And I mean, it probably goes without saying, but do then follow that advice. Where you're lending to a company with a defined benefit scheme, if things go wrong, you really need to have established a solid defence that you did consider the scheme and that anything that you did was reasonable. Now, it's a defence to have acted reasonably, but you need to be able to show that that was the case. So, do keep notes, do show who you spoke to, what advice you took, and why you took the decisions that you did. Because then if things do go wrong and you have to enforce against the company with the DB scheme, you can show that actually you haven't committed an offence under the Act, notwithstanding that actually things may have gone wrong. And so I think that's just kind of the main takeaway here. It's not that you can't lend to these companies anymore. It does need thinking about, and we'd advise you to kind of take expert advice at the earliest stage possible as soon as you know about it. And that's it.
Thanks, Nick. So, yeah, just to summarise from my perspective, I agree, the intention is not to inhibit normal banking activity, but if you've got a DB scheme now funded less than 100% on a buyout basis or on 100% on this low dependency basis, then it will slow down the whole process. Exercise care. There is no safe harbour for banks, and the legislation is deliberately widely drafted so it can include an employee or a director of a bank. And then to put all of this in context, UK listed companies with defined benefit schemes issued 81 profit warnings in 2024, according to EY Parthenon. And so there must be concerns among those over how they will weather the current economic conditions, and also how they're going to look after their defined benefit schemes properly from the financial perspective. So, if you do come across a client with a defined benefit scheme, make sure you and the trustees are all taking proper advice, and we're here to help.
That's it.
And that's us done. Yep.
Thanks a lot. I will pass over now to our colleague Aisha Hassan, who will give a real estate update.
Thanks, Nick. So for those of you who don't know me, I'm Aisha Hassan. I am a partner in the real estate team and I head up the transactions team in London. Next slide, please. What I'm going to cover today is a review of recent and upcoming changes and the impact on you. So what I'm going to cover is, first of all, the consultation on the right to renew business tenancies. I'm then going to move on to the new powers local authorities have, which can mandate rental auctions of vacant high street premises, and they're going to finish off on the proposed reform in relation to energy performance certificates, EPCs. Next slide, please. So starting with the consultation on the right to renew business tenancies. Next slide, please. Sorry. So as you may or may not be aware, there is a consultation which the Law Commission are doing at the moment in relation to the right to renew business tenancies. That comes to an end on the 19th of February this year. It's being done in two parts. The first part is the model of a security of tenure and what they have come up with is 4 possible models which secure tenure can look like going forward. Once they have decided that, what they'll then do is go to the second part of the consultation and look at the technical side and work out how best to do the various things in order to make the model of the security tenure that they've decided go moving forward. Next slide, please. So what is the current position? So under the Landlord and Tenant Act 1954, that gives business tenants in England and Wales the right gives you security of tenure. What does that mean? That means a tenant at the end of the term can 1, stay in the premises, and 2, require a new lease. This, however, is subject to the landlord being able to eject on certain grounds on the new tenancy. The common ones tend to be redevelopment or occupying the premises themselves. If the parties can't agree what they're going to do, then it'll go to a court, and the court will decide what the renewal tenancy will look like. The default position is security of tenure, i.e., at the end of the term, the tenant has a right to renew, but parties can opt out of that using a statutory contracting out process. Next slide, please. So the Law Commission has decided to look at 4 possible models. The first one is mandatory security of tenure. That means all tenancies would be protected. So at the end of the tenancy, the tenant has the right to renew, and there's no way of coming out of that model. That would be the case across the board. The second one is the current position that we're now in, which is a contracting out regime. So again, the position at the moment would be the tenant has the right to renew at the end of its term. However, if there's been the contracting out procedure, then the tenant would not have that ability to do so at the end of the term. The next one is the opposite of that, so the contracting in regime. So at the end of the tenancy, all leases would come to an end, unless there was a contracting in procedure, which would mean that they would have the right to renew at the end. And the final one, which is maybe not a surprise, is that they just get rid of security of tenure altogether. Next slide. So why do you care from your perspective? Well, changes to security of tenure could impact on property valuations. Obviously, if tenants have stronger renewal rights at the end, properties will be seen as being less flexible, and that could reduce their market value. Depending on the portfolio and the customer, it may be important that there is the ability to redevelop or re-let the premises. Obviously, if you've got stronger tenant rights, it means it could be difficult to sell properties, again affecting security. Obviously, there needs to be a risk assessment done in terms of what portfolio customers have, and looking at that and look in terms of, whether it's better to have stronger renewal rights or the opposite. Obviously, the whole point about stronger renewal rights is you've got that guaranteed income stream, which obviously is attractive and probably seen as lower risk, but in terms of the wider picture, it's seen as being less flexible. And obviously, this legislation has been around since the 50s, so we need to look at market dynamics. Whatever the proposed reforms end up at, they're going to have to balance landlord and tenants' interests. If they do so, then there will become a probably more stable rental market. What is not certain at this point in time, until they work out the consultations and whether obviously it becomes law, is the impact this will have on yields or property demand. So moving on to high street auctions. Next slide, please. So on the 2nd of December 2024, the high street rental auctions came into force. This is part 10 of the Levelling Up and Regeneration Act 2023. And what it basically gives is local authorities the ability to make there be compulsory rental auctions of vacant premises. The purpose of this is quite straightforward. It's to reduce vacancy rates and improve the use and perception of the high streets. Next slide, please. So how does it work? So if you've got a premises which has been unoccupied for 1 year or 366 days in the last 2 years, the local authority can conduct a rental auction. Obviously, before they do so, there is a 2-stage notice process with the landlord's ability to appeal. So what would happen is the local authority would identify your unit. It would then serve a notice on the landlord. The landlord would then have 8 weeks to basically find a tenant, and the tenant would need to enter into that lease in that period, and the lease would need to be a minimum of 1 year. If it doesn't happen in that 8 weeks, then there's a 2-week period in which the local authority can then serve another notice on the landlord. In that time, the landlord can either counter notice or try and appeal on grounds. Again, an appeal ground would be the landlord actually occupying that unit by way of example. If that nothing happens in that 2-week period by the landlord, then the local authority then can move on to a auction at that point in time, and it has 14 weeks to conclude both the auction and the new tenant entering into the relevant tenancy at the time. One of the key features of this rental auction is there's no minimum rent. And the other point to know is that local authorities can make landlords carry out pre-tenancy works, obviously at their cost. These lettings, there would be a minimum of 1 year and a maximum of 5, and security tenure would not apply in these situations. Next slide, please. So again, from a lender perspective, why do you care? The biggest point is in relation to consent. Often in a facility agreement, we'll see that the lender has to consent to a new lease. In this scenario, there is no option or obligation on the local authority to go to the lender for consent. It's deemed from the mortgagee and it's deemed from the superior landlord. Looking at security, if a lender will have a right to enforce its security if the borrower defaults and they need to sell the property. If you've got a tenant paying an auction rent, which will be well below the market rent, this could deter potential buyers. Looking at rental income, obviously, when you've got a property, you want income. As we've already said, there's no minimum level of rent for these sort of auction transactions. So you could have a successful bidder paying very little rent. Obviously, this could impact on the market value, and obviously it doesn't generate any income, so that could be a problem. One of the interesting features in relation to these lettings is the repair obligation. There is no full repairing obligation. So what would happen is in this letting scenario, a schedule condition would be entered into, and the tenant would just basically need to repair in line with that. This would be a knock-on effect for landlords, because landlords would then need to look at spending money to get the premises to a certain standard. And then there's obviously the market impact. If you've got a high street, for example, lots of auction rents which are low or well below market, then there's possibly an impact on value and the area generally. Because this is so new, it's very hard to tell how it's going to affect the high street rental market in any event. The backdrop of all this, however, is this is a discretionary power to the local authority. So the questions to ask is, does the local authority have the appetite to do this? And does the local authority have the resource to do this? Given the fact this has only come in on the 2nd of December, it's very early days at this moment in time, but I manage the amount of time it will take to identify, do all these processes and stuff will need a lot of manpower. So it'll be interesting to see actually how this plays out and whether the local authority actually does use this power that it's been given in December of last year. Next slide, please. Thank you. Energy performance certificates. Next slide, please. So again, there's another consultation which comes to an end on the 26th of February. This is consultation in relation to the energy performance of building framework. And this is looking at changes in relation to energy performance certificates, EPCs. Display energy certificates, so DECs, just for not avoid a question, but a question. A display energy certificate is one for public buildings, but it's basically an EPC for those buildings. And then the final area it's looking at is revising air conditioning inspection reports. I'm not going to go in any detail on the last point, safe to say that there's been a lot of non-compliance in relation to these reports. So they're trying to clamp down in terms of penalties, but also ensuring that when there is a report, that whoever is responsible for the air conditioning actually puts the air conditioning to the right level. Next slide, please. So the objectives. So what the government has wanted to do is make an EPC helpful for everybody. So you look at EPC and go, compare it to a building, go, right, I can see how it compares to another building. I can work out how to lower my fuel bill. I know how to reduce my carbon emissions. So I don't think in that sense it's a bad thing that they're actually looking at this at the moment. Obviously, the government's got its wider goal, achieving net zero emissions by 2050. And as a result of that, they need the EPCs to support that goal, to effect changes so they can hopefully get to that level by 2050. Next slide, please. So the key changes, one of the key ones is the validity period. So at this moment in time, EPCs last for 10 years. If you've got DAC, it's between 7 and 10, and that depends on the floor plate of the building. Other proposals include requiring an EPC when the existing EPC expires. So what happens now is you get an EPC, and when it expires, there's no obligation to renew that EPC unless the property is relet. Getting an EPC before a building is marketed for sale or rent. At this moment in time, you can basically decide you want to sell a property or let a property and then commission an EPC at that point. That will tick the box for requiring an EPC, but what they're wanting to do is go one step further and ensuring that the magical piece of paper is there before you go on to sale or renting that premises. The next one is in relation to houses of multiple occupation, where a single room is rented out. At the moment, the legislation is such that if the whole house is rented out, then you need an EPC. But if it's one room, an EPC is not needed. And they're also looking at heritage buildings as well. They're looking at also updating the EPC metrics. So the one that overrides everything at the moment is carbon emissions. And I think for non-domestic properties, that will still be the driving force. However, for domestic EPCs, they're looking at energy consumption, fabric of building and other things, and basically looking at other things to add to the metrics to decide what the EPC rating is of a building. The other thing, for the sake of completeness, is they're looking at overhauling compliance and enforcement. At the moment, there isn't much enforcement or for non-compliance in relation to what is required. So they are looking at increasing the penalties, but also looking at the people who do the enforcement and making sure they're effectively fit for purpose for doing this, and the assessors who do the EPCs more generally. Thank you. So from a lender perspective, so if you've got the situation where you have more frequent EPCs and obviously stricter energy efficient standards, there could be an impact on valuation again. So obviously properties with lower EPC ratings may see a decrease in value. Obviously, if you've got properties which fail to meet the EPC requirements, that means they may be harder to let and may impact on loan defaults. Again, there might be a time to kind of look at reassessing risk profiles of the wider portfolios of the various customers, depending on who you lend to. In terms of investment requirements, obviously, to meet the relevant standards, whatever they may be, borrowers may need additional sums to upgrade the properties to meet that level. The other point is in relation to market dynamics. So changes to EPCs could also influence the rental market, and it could drive higher vacancy rates for non-compliant properties. This could obviously affect rental income projections and overall market stability. Next slide. I'm going to hand back to Liam for questions.
Fantastic. Thanks, Aisha. Yeah, we're going to move on to any questions, including one or two pre-submitted questions. Just once again, if you do have any questions for the panel today, if you drop those into the Q&A function, ideally, if you're happy to, along with your name and your organisation, and we'll do our best to come to them all. I'm actually going to come straight back to you, Aisha, but I suspect you probably covered most of it off in your slides there. So we had a couple of comments prior, hopefully, as I say, covered off in your slides today, but appreciate EPC is quite a broad topic. I'm wondering if perhaps maybe people could reach out to you directly afterwards if they've got specific queries around EPCs rather than you trying to cover off the whole thing in the time that we've got left to us.
Yeah, that's absolutely fine. I think EPCs is quite a broad topic anyway, and it's forever changing. Obviously, the related topic with that is MEES, so minimum energy efficient standards. The EPC, this is solely relating to EPCs in that world, not to do with the minimum standards. So we obviously with the new government, the expectation is there will be some consultations and changes in relation to the MEES, which obviously is a standard, and the EPC is there to kind of give that standard effectively. So interesting to see what happens, because there were certain deadlines for this year. So, for example, there was a suggestion by 2025, residential properties had to have a C standard. That's gone. And then there's various deadlines in 2027 and 2030. And although at the moment all those have been reprieved, but my expectation is once the EPC framework has been looked at, that the government will then look to the MEES to try and obviously marry that up and make sure everything's going in the direction of sort of net zero carbon emissions, etc. In 2050 and more generally.
Sure. Well, look, as I say, we'll circulate this this presentation and the contact details as well after the event. So if anyone does have any specific questions, please do feel free to reach out as well. And then just moving on, Tom, there were a couple of pieces that I don't think we got to on your slides there, which are a couple of common questions. So the first one there was, can the bank seek to challenge a transaction where monies are transferred to an account outside of the bank prior to the onset of insolvency proceedings?
Yeah, thanks, Liam. Yeah, so these are just a couple of questions I was just covering off at the end, which I didn't get to because of time. So on that, the answer is probably not. For set-off to apply, the whole rationale on which set-off does apply is that the bank, there's a credit balance, there's mutual debt, so the bank has a credit balance that it owes in the form of a debt to a customer, and then the customer owes a sum of money to the bank, and then set-off can apply. So we've seen it a couple of times where liquidators in particular, or insolvency practitioners, ask a company to transfer money outside of its account with the bank to another account, generally sort of a client account or a separate account with the insolvency practitioner on account of that insolvency practitioner's costs. Now, what that has the effect of doing is moving the money outside of the remit of the bank so that set-off can't apply, which is exactly the reason why the liquidator or insolvency practitioner asks the company to do it. So those monies can be earmarked for their fees, generally speaking. Also, there are some assets available in the liquidation, so the IP is not taking in a complete punt when it comes to asset realizations. There has been some R3 guidance on this point, which, well, unhelpfully essentially just concluded that's quite sharp practice from an insolvency practitioner's perspective, but there's nothing necessarily inherently wrong with it from an ethical perspective. And if you're wearing your sort of insolvency practitioner hat rather than your lender hat, actually them doing that and ensuring that set-off doesn't apply ensures then that the lender isn't put in a better position than they should otherwise be on insolvent liquidation, and it ensures that monies are available to meet insolvency practitioners' fees, or at least be available to the general pool of creditors as a whole, which can then be distributed on a pari passu basis. It's not desperately helpful for lenders. As I say, I've seen it a couple of times. I'd like to have a more satisfactory answer from a lender's perspective. I think my only sort of takeaway really in relation to that would be, if you are concerned as a lender that a company might be looking to appoint an insolvency practitioner imminently, or you're aware that certainly, there's been various triggers that have required a mandatory referral into restructuring, whatever it is, ensure you're acting quickly. And if set-off is on the table, look to sweep the accounts sooner rather than later, because you're far better having applied set-off and potentially need to return some money to fund an insolvency procedure, rather than try to scrabble around after the money's already left the account, because there's very little you can do.
Thanks, Tom. And then the last one also for Tom is set-off available where the bank has security? Does the position change if the bank is only partially secured? So, for example, where there's a B-bills liability, and is the bank able to specify which portion of its debt is setting off against?
So as I sort of mentioned earlier, set-off will still apply even when, insolvency set-off will still apply even where you've got a secured debt. Contractual set-off will also apply in the usual way. So the answer to the first question is yes, set-off will apply where the bank has security. And then in relation to the second point, in terms of where the bank has partially secured and unsecured, the bank's entitled to apply set-off as it sees fit against the portion of its debt that is most advantageous to the bank. Generally speaking, therefore, the bank will apply set-off as against its unsecured debt first, on the basis that it will then expect to recover in full, hopefully, out of the insolvency procedure and the realization of the secured assets. So in the case of a B-bills liability, if you've still got any on your books and you're treating that as an unsecured debt, then yeah, I would absolutely usually expect that the bank will apply set-off, apply those monies against the B-bills liability to reduce its unsecured indebtedness to the greatest extent possible, and then rely on its security for the balance of the sum.
Fantastic. Thanks, Tom. I think that's all of the questions pre-submitted and otherwise. So yeah, just finally to wrap up, thank you again to all of our speakers today for their time, for their excellent talks. Hope that everybody on the call found that interesting and helpful today. Once again, we've dropped the feedback form in there into the Q&A. Please do consider giving a bit of feedback. We're very happy to hear your thoughts, anything that you might like to hear from us in future. And you can also keep an eye out on our website as well. So you'll see other events that are upcoming on the website, things like our recent FDI report on foreign direct investment. Do take a look on there, and also on LinkedIn. Give us a follow, and you will see events and things like that coming up on our LinkedIn. So otherwise, it's just for me to say thank you to everyone for joining us today, and hope that everyone has a great 2025. Thank you.